Well, good afternoon. This is Norm Ward, Chief Medical Officer for OneCare Vermont, and we are pleased to welcome you to today's session of Noontime Knowledge, Advanced Care Planning, the Good, the Bad, and the Ugly. And we are so fortunate today to have with us Cindy Bruzzese, who is the Executive Director and Clinical Ethicist at the Vermont Ethics Network. She also chairs the Ethics Committee for the State of Vermont Department of Disabilities, Aging, and Independent Living, which is the AIL organization. Serves on the Clinical Ethics for Central Vermont Medical Center Ethics Committee, and also directs the statewide task force on palliative care and pain management. She earned her BA from Colby College in Waterville, Maine, a master's in public administration from UVM, a master's in clinical ethics from Clarkson, and the Icahn School of Medicine at Mount Sinai in New York. And additionally, she holds a certificate in bioethics with specialization in health policy and law from Union Graduate College and the Icahn School of Medicine. I can't think of anybody more qualified to lead us through this discussion today. Just to let you know, this session will be available for CME credit. You should have received a QR code that you can use to access the UVM Medical Center CME, the UVM CME department for claiming your credit. The credit is only available for those that are participating live. The session will also be recorded and will be available on the OneCare website. So I think without further ado, I'm going to invite Cindy to lead us through the presentation. Thank you for being here.
Great, thank you. All right. Hold on, I think we're getting to the slides, right?
Should we mention that
there was a slide that said, so you all are muted, I guess, right now, and then but there's a chat box, so if you have a question or you want to chime in, please use that, and we can unmute you or you can unmute yourselves. So thank you for that kind introduction, and we'll just dive right in here. So the goal for today, or my hope for all of you, is that at the end of this session, we'll all be kind of clear in terms of our terminology and best practice when it comes to advanced care planning. We'll be able to learn and understand more, I guess, about the scope of authority of different kinds of medical decision makers. I get frequent questions relative to who can make what decisions when at my office. And then I think we'll dive into some cases that really, hopefully, will illuminate the complexity that all of you probably know better than I that surrounds medical decision-making when we have advanced directives and coast orders and an array of different folks trying to make decisions. So that's the plan for today, and I will welcome your questions or comments throughout. So just to orient us all to kind of being in the same space when we're thinking about advanced care planning, when I talk about advanced care planning, what I'm thinking about is this ongoing process of discussing, understanding, planning, and ultimately documenting an individual's goals, values, and wishes for future health care. That's sort of what advanced care planning is at its broadest umbrella term. I'm sure that you all, in various stages with the clients and patients that you're working with, are engaging in different levels of advanced care planning. You may be doing sort of disease-specific advanced care planning, where you're planning in the context of a chronic progressive disease or a serious illness. You may be doing planning with folks who have advanced end-stage disease, and really we're focusing there more on goals of care at the end of life. So all of that sort of is encompassed within this broader term of advanced care planning. But when I think about advanced care planning, I'm thinking about it that we start it early and often with people who are young and healthy, and then we progress with our conversations as they progress in their age and their health. Why it's important, and I think at some level we all know that this is a good thing to do. I think it's been a long time coming to get good data and research around what we know about the benefits of advanced care planning, but there was a really great, Health Affairs put out a whole issue a couple summers ago that was dedicated to end of life and advanced care planning, and I think we know now that doing advanced care planning well and sort of embedding it into how we deliver care does improve the quality of care for patients. Patients are more likely to receive care that's consistent with their preferences and priorities, meaning that we're actually doing things for patients and not doing things to patients. Patients are less likely to die in the hospital, and they're more likely to receive hospice care. And I think consistent with not just doing things to people, what we find is that people receive fewer non-beneficial medical interventions. We're doing things for them that they want, and frequently they're choosing palliation over aggressive measures. We also know from the research that patients and families are more satisfied with their overall care that they get when there's been some conversation and people feel like they're all operating towards the same goal. And there's also better surrogate communication with the healthcare provider at the end of life. When there's been conversation and planning ahead of time, it helps everybody sort of be operating from the same playbook, if you will, so that the communication is improved. So these are all the reasons why we should be doing it. We still aren't there yet in terms of doing it in the way that it is probably best suited to optimize all the things that we can gain from doing good quality care and having that kind of discussion with patients and families early and often and revisiting people's goals and priorities throughout their health and their aging process. But I hope that that's sort of where we're headed in terms of all the work that we're doing in healthcare. So when we think about advanced care planning, we should be thinking about it on a continuum. So something that we start when that 18-year-old is graduating from the pediatric practice and moving into adult family internal medicine. They're changing providers, and we should be starting early with them with just something simple as naming a decision maker. Because as you all know, it's not automatically your next of kin that gets to make a decision when a person no longer has the capacity or has their capacity is impaired for a short period of time. It's not automatically parents that get to do this. And I have to say this week I've had 3 calls, well, last week and this week, 3 calls from people whose kids are going off to UVM, which started, I think, yesterday, wanting to know if they could send their healthcare agent documentation to the Vermont Advanced Directive Registry for their freshmen attending UVM, which I just think is great. 5, 6 years ago, I never got these calls, and we're starting to get more and more of them each year in the last few years as people are recognizing that sudden accident and illness can happen even to young, healthy college students, and we need to have a plan in place to make sure that the healthcare team is able to contact the right people and that those people actually have authority to make decisions while we're working to hopefully improve and restore the health of this individual. So we should be making sure that we are tackling these things in an ongoing way. So naming a decision maker, and as someone is advancing in age or developing maybe a new chronic illness, we're beginning to speak more with them about what are their values and preferences, what does matter most, and are there things that they are important to them that they want to try to do? Are there things that they really want to try to avoid? And how can we create plans of care that really support what they value? And then obviously as people are approaching end of life, we want to make sure we're also having those conversations about are there things that they would like to avoid if their situation worsens? What are the priorities at that time, and how can we do our best to make sure that we're putting in place those plans of care that really represent what's most important to that individual as they approach end of life. So making sure that we're thinking about this not as a sort of one and done kind of a process, but actually something that we intend to revisit as people age and as their health status changes. So I like this sort of pyramid outline because I think it breaks it down into bite-sized pieces that we can tackle in shorter amounts of time. Frequently what we find is we just put this whole conversation off until the very last moment, and then we're having to try to do everything that's contained within that pyramid at the end of life with someone who maybe has capacity is sort of in question. It's a lot for you as healthcare providers to try to get in to a very busy patient-family meeting. It's also a lot for that patient and family to try to digest all at once. So we've learned from the research that breaking it down and meeting people where they're at and doing this as a progression is actually where we get the best results. So that's really, I think, the focus of my work at the Ethics Network in terms of putting advanced care planning out there as something we need to start to embed into our workflows, but also that we have tools that kind of line up with this sort of stepwise approach to doing it. So I think that leads us to this next slide, which is the tools that we have here in Vermont for documenting health decisions. So again, we're having these conversations and we're working through this process and meeting people where they're at, and we're using a tool that matches where we are in that conversation. So with these 18-year-olds that are heading off to college, we're really only tackling the appointment of a healthcare agent. You don't need to be dying to need an agent. Something unexpected could happen. We just want to make sure we're talking to the right people and we've got the right people there to make decisions for you if something unexpected should happen. Then we also have a longer form, a short form and a long form, where it really gets more into the what's important. It also has a place where you can document the who, because I'm sure my children will eventually update their agent forms by appointing someone other than their mother to make decisions for them, but for now I'm it. But they have a chance to update that and also to give a little more information about what's important to them. Things like things that they would or wouldn't find acceptable, how they feel about trial courses of treatment and certain types of interventions, if they have preferences around organ donation, or if they even have thoughts about their funeral or burial. All of those things can be encompassed within either the short or the long form advance directive. The long form is long. It's about 23 pages long. It is a daunting document for probably most people, but a very good tool for people who have experienced psychiatric disease or mental health issues, who have needed to maybe receive involuntary medication or involuntary hospitalization. It allows them the ability to communicate what's worked well for them in the past and what hasn't worked well. Drugs maybe that would be useful and drugs to avoid because they've had a bad response to that. It even lets them give information about facilities that have worked well, other facilities that maybe haven't worked as well for them when they're in an acute state. They can also communicate about if a guardian might be needed either temporarily or long-term, people that they trust that know them well. So this is a great tool, very underutilized, I would say, in that population, but a very useful document if we start having those conversations with people, not when they're acutely ill, obviously not like with anyone, but when they're doing well and they can think clearly about their goals and values and the things that they want to have happen and things that they'd like to try to avoid. We also have COLST orders in Vermont. I don't know if there are people from New York or New Hampshire on this call, but New York uses a MOLST form. Vermont has COLST, and if you're from New Hampshire, you have POLST. So there's an array of these OLST orders, which I'm sure you're all familiar with. These are different from advanced directives, and we'll talk about what those differences are in a moment. But we have this also ability to document medical orders. And then, of course, in Vermont, we have the Advanced Directive Registry. This is a database where people can submit their advanced directives, not their medical orders. Those belong in the electronic medical record and with the individual. Advanced directives belong with the individual, with their healthcare provider, and also with the Advanced Directive Registry. It allows people to have, or hospitals primarily, but other facilities as well, to have more immediate access to people's documents. I think we learned a long time ago that when people do these, they tend to check it off and then stick it in the drawer somewhere, and when we need it, no one can find it. So the goal with Vermont creating a registry process was to make sure that hospitals would have more immediate access to these documents and not relying on family members scouring the various junk drawers and file cabinets within someone's home, or worse, waiting for the bank to open so they could get to the safety deposit box to get the document out. So this has been a useful tool. We are seeing about 350 Vermonters per month registering their documents at the registry. We have over 40,000 Vermonters now with registered documents in Vermont's registry, so we're doing pretty well relative to other states who have registries. We've got a fair amount of Vermonters using this resource. So again, any questions along the way, please just flag us and we will take your question. I just want to distinguish before we get into sort of the who's making decisions, the real difference between advanced directives and COLST orders, because I still see these terms being used interchangeably, even though they are very different types of documents. Oh, that's not, sorry, I was looking at a question, but it's not for me. Technology, totally outside of my sphere. So advanced directives, as we said, these are preference-based documents. They're completed by people who have capacity to make decisions for themselves, and they're really future-oriented. We're thinking about a time in the future when we can't make decisions for ourselves. Frequently, because this is future-oriented and there is no crystal ball, they're nuanced documents, and they often require some discussion, some context, and even some interpretation, because the situation someone finds themselves in may not be the situation they addressed in their document, and we may need to do some application of values for a different situation and see if we can apply that to the new situation. The other thing to remember is only the patient, or if they're not in a hospital, the law refers to them as a principal, only someone with capacity can complete or update their document. All too often I get calls saying, we have a healthcare agent here who wants to update their mother's advance directive. Well, she can't update her mother's advance directive, only her mother can update her own directive. And if her mother knows...
Hello, I'm sorry, this is pre-registration at the University of Vermont Medical Center.
Hi.
Hi, I just got thrown into the middle of, sounds like what was a conversation here, I'm sorry.
Yeah, I think you've got the wrong number.
Okay. All right, moving on. So only a person with capacity can complete an advance directive, and we're not able to update or change someone's advance directive once they no longer have the capacity to do that for themselves. Cold orders, on the other hand, are different. Oh, wait, we have a question. Do the states that have advance directive registries charge people to register their advance directives? Great question. So in Vermont, we don't charge for that service if you're a Vermont resident. I'm not sure about other states. There are a couple of states that, there's probably about 10 or 12 states that have registry systems, and then anyone's free to use the U.S. Living Will Registry for a fee. But I couldn't answer the question as to what other states are doing. In Vermont, we're not charging for Vermonters to submit their own documents, which means when someone moves out of Vermont and they are no longer a Vermont resident, we have negotiated with the registry to allow them to transfer their document out of Vermont's registry and into the overall national U.S. Living Will Registry for a nominal one-time fee. Or they can keep it in the Vermont registry and it will still be able to be accessed, but they can't update, or we won't service that account any longer, or they can just remove it entirely. So we are paying attention to when people move out of state, and so that Vermont tax dollars aren't being redirected to support other out-of-state residents. So in terms of COLST orders, these documents are quite different actually than advanced directives. They still sort of fall under a tool for advanced care planning, but these are really when we're starting to think about folks who are seriously ill, have advanced disease, and we wouldn't be surprised if they died within the next year. These should be the outcome of a shared decision-making conversation between a clinician, and by that I mean a physician, a nurse practitioner, or a PA, and the patient. They're medical orders. They require informed consent, and they are really intended to guide the current treatment plan. So quite different than an advanced directive. Because there is this process in place where we are having a conversation with a patient if you're a healthcare provider, and you're talking about their current medical condition and their goals and values, and having a discussion about what's achievable, what would be helpful based on their goals, what we want to avoid. These are then really immediately applied in the current treatment situation. The other difference between these and advanced directives are that someone else, meaning someone other than the patient, if the patient lacks capacity, can consent for a COLST order. So that's very different than what we're seeing with advanced directives. So we just want to be clear what kind of a tool we're looking at and what we're working with when we are trying to make decisions, particularly when we're working with surrogates who are making decisions for others. Any other questions relative to the documentation itself and anything along those lines? No? Okay. We'll respond to the chats as they pop up on our screen here. In terms of who's making these decisions, well, as you all know, patients get to make their own decisions if they have the capacity to do so. We also assume everyone has capacity, so they don't have to prove it. So we operate from the assumption that adults have the capacity to make their own decisions, and we let them make their own decisions, which means they get to say yes to things and they get to say no to things. Even if we think it's a bad idea, they get to make the decision. They can say no, even if we think this is going to result in a bad outcome or even death, we still let them make that choice. Surrogate decision makers are different. These are anybody who's not the patient, who's making a decision for someone who lacks capacity. And in Vermont, we have special kinds of surrogates. We have healthcare agents. You used to refer to these folks as durable powers of attorney for healthcare. In some states, they call them healthcare proxies, and you see that language frequently in the literature. These are people that are appointed through an advance directive. So a legal document doesn't mean they have to go through a lawyer. People can do this at their kitchen table as long as the documents are properly signed and witnessed. But this is a capacitated person naming somebody that they want to serve as their decision maker if they can't make decisions for themselves. We also have guardians in Vermont, a couple of different kinds, which we'll talk about. These folks are given the authority to make medical and health decisions by the court. So a legal process, a legal proceeding has been undertaken to confer the authority to make medical and health decisions to someone else. They may or may not know the person, depending on what type of guardian is in place, but they have the ability to consent for most medical and health treatments. And then we have this other large group of people that we just call surrogates. And generally, these are family members or people with a known close relationship to the patient, but they have no actual legal authority to make decisions. These are just the folks that are showing up at the bedside for their family member who didn't do any planning, who care about them, and are trying to help all of you as clinicians make good decisions while this person is not able to make decisions for themselves. So that's sort of our landscape of decision makers in Vermont. When it comes to guardians, we've got two different types, and I don't know if it's just because people now know to call me or are starting to call me, but my sense is that we're interacting a lot more with guardians as we have an aging population and people that are developing dementia or other types of diseases that are really chronic and progressive and impairing their ability to make decisions. So we have public guardians. They get appointed either through the family court or the probate court, depending upon which bucket you fall into. If you're a person who has been determined to be developmentally delayed prior to the age of 18, and that's through Title 18 of Vermont statute, you would qualify for a public guardian. If you are also an elder, and by that it's defined as someone at least 60 years of age, you may also qualify for a public guardian, and that would be through the probate court under Title 14. So you'll see there's a pretty big gap between people who are determined to be developmentally delayed prior to 18 and someone who's 60. So there may be people in that window of 19 and 60 who could benefit from a public guardian, but we really have no mechanism within Vermont to get them access to public guardians. The rest of the people we think probably have someone in their life that could step up and serve as a private guardian. And so private guardians can either be paid or voluntary, and those all go through the probate court, similar to the elders who are under public guardianship. So it's important as healthcare providers, when you're working with individuals who have guardians, to understand what type of guardian you've got in front of you, because their scopes of authority differ and their process for consenting to things differ. And also to really be clear what authority that guardian has been given. So asking to see the guardianship order is really important, that become part of the chart, the medical chart. Because oftentimes guardianships are crafted around what the needs are of the individual, and the standard is the least restrictive environment. So that means maybe this person just needs some help with their money, but they are still able to make their own medical decisions. Or maybe this person needs help with their medical decisions, but they're still managing their finances. So you really do need to look at that paperwork to see whether or not the person who's claiming to be the guardian actually is the guardian and what scope of authority they really have to make sure you're working with the right decision maker. So we see this frequently where people say, I'm the guardian, but they've been acting as the guardian, but there's never been a formal guardianship hearing. So they may not actually have any legal authority to make decisions. So really important when you're navigating decision making to just understand and to have the paperwork to just confirm that this is in fact the right decision maker. Any questions? All right, let's think about a case. And here it would be helpful for people, I don't know if you can't probably all unmute at once, but maybe you can, I'm not sure. So let's think about a 70-year-old female. She was moved to long-term care about a year ago. She'd had a stroke and her caregiving needs had increased to a point where they just couldn't really manage her at home. And she was just admitted to the hospital 10 days ago for cardiac reasons. She is being assessed as having advanced frontal lobe dementia. She's now nonverbal. She can't perform any of her activities of daily living any longer. And even at her best baseline, she is severely agitated and combative. She did do, before all of this really happened, she's taken a pretty quick downward turn in the last 5 years, but she did complete an advanced directive in 2014 where she named a close friend as her healthcare agent. And in her document, she indicated that she wanted to be resuscitated if something happened and to get, sort of trial courses of treatment. But she also said in her document that she wanted comfort care and to get hospice care if she's dying. Her husband was appointed guardian last year when he was trying to get her admitted to the nursing home. The nursing home wanted a guardianship in place for decision-making reasons, and so the husband was appointed the guardian. And about 6 months ago at one of the care planning meetings with the primary care was able to come into the home, he consented for a coast order. So the hospitalist now in the hospital is looking at all of this and is recommending that based on where things are, that a comfort-based plan of care is appropriate, thinks DNR is also appropriate given what's happened to her and what the prognosis is looking like. But the team is really concerned about whether or not the COLS that they've got in front of them is valid. What do you guys think? This is an actual case. I love getting these calls in my office. People have any thoughts about how to untangle this one?
Are they all still muted?
Are they all muted or?
They can unmute themselves as well if they wish to speak. We can unmute people.
We're unmuting you, so there's no hiding. Anybody have any thoughts about whether they think this coast order is valid, or is there something we should be looking at? What do you think?
I would go with the coast order.
You would go with the coast order just because, or?
Injured, they can send them to us.
I guess I'm putting my place lying there in the bed.
Them to work safely so that they're not.
And I'm also being the husband. And it may not be legal, but it seems to be that my sense is that the coast order, if she's really having that much of a tough time being oriented and she hasn't got much more to look for, it seems reasonable that the coast order, the husband knows her well and has decided, he said some time ago that he wanted the coast order. So it doesn't seem unreasonable. I don't know whether the doctor's involved here at all.
So what do people think about the fact that she named her close friend as her healthcare agent a few years ago, but now her husband's her guardian?
Yeah. I'm not a lawyer, so I don't know. All I know is what I would deal with was with the lady that I'm dealing with, not so much the issue, the legal issues.
So I guess the question is, does the guardianship trump advanced directive or not?
Right. So that is one of the issues we need to sort of sort out here in terms of the fact that she named someone else and now her husband's got decision-making authority. So what do we know about sort of that order of operations? So let's look at, where is our, how come this isn't advancing? Can you advance one? So under the current framework, the legal framework that we're operating within here in Vermont when it comes to medical decision-making is that if there was an advanced directive completed prior to the guardianship, the agent named in the advanced directive maintains the authority for all health decisions unless the court modified that. And we have to wonder if the court knew about it when they were doing the guardianship. So it's very frequent for a court not to even know that there was a document when they go through a guardianship proceeding. If there is no agent, the guardian would then use the preferences and priorities put in the document by that individual at a time of capacity and knowledge of their goals and values to guide the decisions. So the agent and or the guardian is still bound by looking at the document and understanding what the person said was important to them and using that as their substituted judgment for making the decisions about preferences around treatment and care decisions. If there was no advance directive, the guardian has the authority to consent for most treatments. So let's go back to looking at the case. So it turns out that her healthcare agent, who is a close friend, is not comfortable making this decision. So she has said, I am removing myself from weighing in on this end-of-life decision. She's just not comfortable doing it, and so she's decided not to. Which means now if the agent, you can't make an agent serve as the agent if they say they don't want to. So the guardian does, in fact, have the authority to make the decision because the healthcare agent has basically recused herself from sort of the end-of-life decision-making. So we do have a guardian who has the authority to make this medical decision, but can he just consent for a coast order when she's got a document that says she wants CPR? Can he say that it's okay now for her to have an order that says DNR and to shift her plan of care to a comfort-based plan of care? What do we think?
But you said her advance directive wants CPR, but also states a desire for comfort. Yes,
don't you love these documents? They're so helpful in these tricky situations.
Sort of mutually exclusive.
So really helpful to know sort of what part of the document should we be looking at based on what is her medical situation. So great question for the physician to say, do we think that she is dying? Maybe not imminently, but she's really at the end stage of her disease. And that is the preeminent goal here. So we should be looking at what her goals are around dying. Or do we think that she's in a state where her situation could be reversible? If so, should we be leaning more toward the aspects of the document that say trial courses of treatment and including CPR? So the medical facts really do come into play, and so that's really where we need that input from the clinical team. So right now the hospitalist is saying, listen, I kind of think that she's not imminently dying, but that is where this is headed. So the hospitalist couldn't say with certainty, like, I think it's within the next hours to days. Wouldn't be surprised if it happened within the next few months, given the cardiac issues that have been sort of ramping up recently, and thinks that this is really, given her dementia and this back and forth from the, long-term care to the hospital is just making all of her agitation even worse, that we should be shifting the plan here and the goal towards more of a comfort-directed plan of care. This is what the medical team is recommending. Mm-hmm. So are people now comfortable honoring the post order? Thinking that it's valid?
It is for me.
It is for you?
Yeah.
This is Norm. I think that a lot of people, back in 2014, when she's creating her advance directive, I think a lot of people are hesitant to say, I don't want CPR, because they're afraid of prejudicing their medical care for the entire future, that somebody is going to interpret their disinclination to have CPR as they're just going to let me go. Mm-hmm. Without any efforts to treat me at all. So I would suggest that the 2014 characterization of I want CPR may have come from that motivation.
Cindy, can you just go to your next slide?
Sure.
Where you spoke of the agent continues to have the authority unless modified by the court. is appointing a guardian considered modified by the court?
No, that's a great question. So typically the court will let stand the naming of the agent because the person at time of capacity indicated this is the person they trust most to make their medical decisions. The court is not usually inclined to remove the authority from that agent, and they're going to craft the guardianship to sort of wrap around the other types of decisions that may need to be made. The only time we're really seeing people to change that is when the agent isn't able to make decisions, or if there's some concern about the motivations of the agent or something that's been presented. But typically they leave the agent to make the decisions.
Can we just pause for a second?
Sure.
Ask for all of you on the phone, if you're not speaking, could you just mute yourself so we don't get background noise? That would be appreciated.
There was just a question that popped up on the screen about whether or not it's appropriate to include wishes for organ donation in an advance directive. Absolutely, it's appropriate to do. I think people do need to remember, though, that an indication in an advance directive for organ donation is not the same as registering as an organ donor the way you would through the DMV or through Vermont's Donate Life Vermont program. So currently right now, if you go to the DMV to renew your driver's license, you can check a box that says, I wish to be an organ donor, I don't want to be an organ donor. That box checking at the DMV is directly linked to the OPO, so the organ donor, the organ procurement group that we're part of in the Northeast, and so you're immediately put in the registry when you do that. Merely, if you signal that you want to be an organ donor on your advance directive, that preference is not directly tied to the organ donor registry. So you would still need to go to the registry to do that. But it is a good signal to your healthcare agent if something sudden happens, and for them to be able to consent on your behalf for donation if that's something that was important to the person and a value that they held. So it's perfectly appropriate to do. And again, on any of these documents, people can customize them so they can fill out the sections that they want to fill out. They can leave other sections blank. I do recommend that if you leave a section blank that they just draw a line through it so that it's clear that they chose not to give any information, not that their omission is, by omission it's an expression of a choice. So I want to let you know one other thing that is true of people who are serving as guardians, particularly if they are private guardian, which this gentleman is in our case, is that while they have the permission to consent for most medical treatments, there are times when they have to go back to court. And right here, the slide that's before you now is from the section of the statute that governs when these guardians, these private guardians, need to go back to court. They have to go back when the person under guardianship objects to the decision. So one thing I want to point out is that just because someone has a guardian does not mean that the guardian gets to have them do things that they're refusing to do. I think there's this sort of misperception that somehow guardians have a lot of power. They don't have that power. So if someone's difficult and refuses to engage in a treatment plan, having a guardian is not going to make them. The guardian can't make them do what they are unwilling to do, unless they have court authority to do it, and we think a lot about what that looks like if we're forcing someone to do something that they don't want to do when they lack capacity. They also have to go back to court if, in the course of the guardianship proceeding, the court had said, listen, these are specific decisions, these decisions must come back to court. And the blue sections of your slide pertain to this case. The guardian can't consent for withholding or withdrawing life-sustaining treatment other than an antibiotic, and except in an emergency, without permission from the court. They also can't consent to a DNR order unless it's under an advance directive, and except in an emergency without a court hearing. So, as we know, the question is, did our husband go back to court and get permission to consent for this DNR order 6 months ago? Was there a hearing? Or is this not a valid order?
Not.
see? All this great advanced care planning. They've got advanced directives, they got cold stores, and still this is an ugly mess. Oh, we have a question. While you're thinking about whether or not you really still think this is a valid order, we've got a question from someone saying that they understand, wait a minute. Hold on, I missed it. I got two questions now. All right. A guardian or agent cannot consent to Act 39, and can you please confirm? That is true. A guardian or agent cannot consent for Vermont's law on physician aid in dying on an individual's behalf because the law doesn't allow for it. The person has to have capacity when they go through the process, and if we're talking to guardians and agents, then we've got a person that lacks capacity. So you're correct. This question is, does the guardian need to go back to court for a DNR even if the DNR paperwork was filled out and consented to by the patient prior to guardianship? Very good question. I would argue no, because it was done before the guardianship even came into play. So I would say the order stands on its own merit because the person had capacity when they did it. In this situation, we didn't have a person with capacity who could consent. I do think you can make a case for, I don't know if you could make the case 6 months ago that the patient was dying and wanted comfort care and hospice care. And arguably, there probably was time 6 months ago to petition the court for a hearing knowing what was happening. But now that you're here and the person's dying, that you probably could make a case that you would honor this DNR order, particularly if she was doing really poorly now and there wasn't time to go back to court. So I would say if she was doing really poorly and the clinical team thought that this was going to happen soon and there wouldn't even be time, then they could put in place the order and probably just have the husband notify the court that this has happened. I think if they are planning to just kind of get her stable in the hospital and then send her back to the long-term care facility, that there might be a strong argument to be made for notifying the court that this is all happening and we've got this order and this is the care that we're recommending. It was interesting that this case, I actually learned about this case not from the hospital or the care facility, but from a probate judge who was a little perplexed because it did land back in the probate court, and they were struggling with the fact that the patient had indicated a preference for CPR, but also said if they were dying, they wanted to receive comfort care and hospice. And we talked a lot about the inconsistency between a comfort-based plan of care and a hospice-based plan of care and doing resuscitation attempt on someone who has an end-stage disease in their dementia with poor cardiac health. So her heart stopping is probably not something that is reversible. So it was an interesting discussion, but one of those cases, I think, that had left people scratching their heads and thinking, what could we have done better in terms of the conversations and the way this unfolded? How could we as a healthcare team have supported the process and making sure that everything was lined up so we could have avoided this?
So what is the current time course for getting back to probate these days in Vermont?
I think it really varies, and it also depends a lot on the facility's relationship with their probate judge. So I know in some places they can call the probate judge and they can get an emergency hearing right away. I think in other parts of the state it's taking longer. We do have 5 new probate judges in Vermont, and so I would encourage hospitals who maybe spend a lot of time in probate court with various patients that they're serving to set up some meetings with their probate judges and begin to develop those relationships, because decisions may be looking different with new probate judges that don't know you as well as your old judge did. So we don't have that much time left, so I want to make sure that we talk about our next case. We talked about those things. So here's an interesting one. A 52-year-old female. She's got multiple medical problems, including diabetes and end-stage renal disease. She ends up in the emergency room. She's confused, she's delirious, she's weak due to uremia. She was admitted and given emergency dialysis. After one round of dialysis, she's definitely more clear. She's still pretty weak. Her labs are better, but nobody thinks she's totally out of the woods. They want her to do more rounds of dialysis, but she's refusing now. She's saying, forget it, I'm not doing it, I gotta get out of here, I wanna go home. This isn't an emergency anymore. When she came in, people felt like it was an emergency and they really needed to do something. But everyone's feeling pretty uncomfortable with discharging her at home because she does live alone. She's pretty unbefriended. She lives a pretty solitary life. She has an advanced directive saying that she wants to live as long as possible, but because she's not that trusting of people, she didn't actually name an agent in her document. She just said she wanted, she wants to live. She's not that old. She's 59. She wants to live, but she doesn't want other people making decisions for her. So what do you guys think? What do we do with this one? Do we let her go? Do we keep her? Can we keep her? Do we make her have more dialysis? Can we make her have more dialysis? What do we do with her?
I don't think we can make her have more dialysis. That's what I think I know.
So you are correct. We'll just talk a little bit about refusals so everyone understands this, that we can't treat people over their objection even when they lack capacity, unless there are always some exceptions. They could have done one of those long-form advanced directives where they completed something called the Ulysses Clause, which would allow them to allow their agent to override their objection, which means they're refusing something, but we don't have to listen to them because they said, I know I'm going to do this at some point in the future. Don't listen to me when I say it. Listen to what I've written down in this document and treat me anyway. She doesn't have one of those documents, unfortunately. So we're in this other world of they lack capacity, will suffer serious and irreversible bodily injury or death if the health care cannot be provided within 24 hours, and one, they don't have an agent or that Ulysses Clause provision in advance directive where the agent's not available, or two, the agent or advance directive authorizes providing or withholding the health care. So when she first came in, it was an emergency. She actually wasn't even refusing. She wasn't consenting either, but we had to do what we needed to do to stabilize her. She's now stable. She's not great. Everyone would feel so much better if she stayed and had a few more rounds of dialysis and was pretty clear. But she's clear enough now that she's saying no. She's able to refuse. So we're not in the world of being able to treat her over her objection because we don't really meet that standard yet. We're not there right now. We're better. So what do people think? Let her go?
Let her go.
I heard let her go.
I mean, my concern is we're going to be back here when she gets uremic again. If somebody discovered her this time, they're probably going to discover her next week when she no longer is terribly lucid, and they're going to bring her back and we're going to go round two.
Oh, you definitely are.
Unless she has an agent.
She doesn't have an agent.
Can a court guardian be appointed?
Well, I think a lot depends on what do we think about her capacity. So maybe we want to get somebody down here to say, do we think she has enough decisional capacity to leave? Can she actually get up and walk out? We have plenty of people, I'm sure you know, in the hospital who have their capacity is kind of questionable, and they say they want to leave and they're refusing, but they actually can't get up and leave. So they're kind of stuck, right? But she probably could get up and leave. So do we think that we want to try for a guardian? Does that really take away her rights to make her medical decisions with a guardian at this point?
Well, this sounds like a really familiar one to me.
Oh, great. How did you solve it?
Well, I didn't, but she ended up, I was at the time working in a facility, and she ended up, my understanding is she was in and out of the hospital many times with emergent need for dialysis, because then she would go home saying she was going to continue dialysis and would not.
Right.
And then would go back. So there was a revolving door, and eventually, again, this is a few years ago, and this is what I remember. There was a capacity evaluation done, a public guardian was appointed, and then she came to live at the facility that I worked at.
Yeah, so that is probably how this will go. Unfortunately, at 59, she does not meet the age criteria for qualifying for a public guardian right now. She is too young.
Right.
So she
But she's
doesn't
60.
Public guardian's not probably an option for her right now. Could be if she continues on this sort of revolving door, I think you described it, process where you get her sort of better, she goes home, she promises to come back, she doesn't come back, then she comes back through the ED, you dialyze her again, she says she wants to leave, and then you're back to kind of what you, I think, were experiencing with the case that you reflected.
Well, and then I've had some cases in the past where they started out with, they were found to not have capacity, but did have some funds, and so the recommendation, or so however it happened, a private attorney took over guardianship.
Right. Yep. So we do have situations where we have a couple of folks in Vermont that are providing this kind of paid private guardianship that is happening while people have funds, until those funds get expended down, and then they can shift them over to public guardianship once they meet the criteria. So that might be an option. So I think I think these are the tricky ones, because she's got documents saying she wants to try and do things, but she's not actually cooperating and participating in a plan of care. So I think a capacity assessment would be really helpful, just to make people feel okay about, if people think she has this decision and we don't like it, we think it's a bad idea, and we're pretty sure she's going to be back here, we're going to at least try, and we're going to try to respect her rights and try to get her a discharge plan in place where we've got a good safety net. Maybe we can circle back to our community partners and see what we can do to try to keep an eye on her and get her, make sure does she have transportation to get to dialysis as an outpatient? Can we set up that dialysis appointment ahead of time and figure out transportation to get her there? Maybe that's a problem. There are all kinds of barriers to people accessing the services that they need. So a really good opportunity to connect with our community partners and see what we can do to try to support her goal of living as long as possible, but knowing that she is probably, if this continues, going to be a frequent flyer, and we may be headed down a path of guardianship, either through private guardianship, or if she qualifies, or some other route. But these, I think, are tricky cases, and even though there's been some advanced care planning, it's not really meeting the need. So let me see. Who does the mental capacity assessment? Who does it, and how does it get done? So typically for people who are in hospital, physicians they're assessing capacity all the time. It's certainly within the physician's scope of practice to do it. If you have inpatient psychiatry, oftentimes they're looking for a psychiatrist to do a formal assessment of capacity. But I think the treating physician is in a good position to assess someone's ability to make an informed decision. Those are probably the two places in a hospital that you would look to. And even probably in a skilled facility, to have the treating physician do an assessment of whether or not we think this person has the capacity to make their own decisions. And then documenting. And I mean, I'd be documenting heavily on this person in terms of what was done, and that you've doing everything you can, because she probably will be back, if not once, twice, or more times, until you're able to come up with a plan that hopefully will keep her out of the hospital. Any other questions or thoughts?
Yeah, so, but if a guardian is named because she's felt to lack capacity, and yet she verbalizes, if the guardian says, go ahead and do dialysis, and the patient says no, and we just learned that we can't dialyze her if she says no, if she says she wants to go home, can the guardian prevent us from sending her home?
So that's a tricky question. So if she is refusing, even if she had a guardian, let's say she's 65 now and she's got a guardian in place, and we're still on this round of where she doesn't like to do dialysis, I would say our options are to go to the court and get permission to dialyze her over her objection. And I would say that that's a pretty heavy lift to say that, because dialysis is not a one and done. It's not like we need her to come in and do a round of antibiotics and then we'll send her home and we won't have to see her again. We're going to be doing this. So what does that mean? Does that mean we're going to have to sedate her and restrain her? And are we really going to do that for 3 or 4 hours a day, 3 times a week? That is starting to look really, really burdensome, and maybe what we should be looking at is a more palliative end-stage renal disease plan of care, where we're starting to think about hospice and what it's going to look like for her if staying home is really an option. So I think those are all parts of the conversation that guardian will need to be having with the care team to come up with a plan that will work for her and is actually consistent with what she can engage with. Because there are times where people are saying all kinds of things, like, I want to live as long as possible, but they're unwilling to do any of the things that are going to get them towards that goal. So sometimes the goal is going to have to shift, and we're going to need to do what the person's really able to participate with, because we can't force people, even if they're saying one thing. If their actions are inconsistent with that, we're kind of stuck. So great question. Any other final thoughts or questions before we wrap up?
I had another question about, you had mentioned earlier about maybe a situation where somebody with mental health issues might, in their advance directive, name people that they felt comfortable with being their guardian during a time where they maybe lacked capacity. How does that work to undo that guardianship when the person maybe is stabilized and becomes competent again?
So it really depends on if the guardianships are voluntary or involuntary. And so I think if someone is, I think we look long and hard at whether or not we're petitioning for a voluntary guardianship where the person is consenting to it, or whether we're down in the land of an involuntary guardianship. So oftentimes we're hoping that they've named an agent, and if we think that this is, I wouldn't be pushing for a guardianship if we think this is a reversible condition and we can get this turned around, because, you know, it's a lot harder to undo an involuntary guardianship than it is to do a voluntary guardianship. So we see a lot of people, you know, I work with people with some of the state hospital that has folks that are in there. They are their own guardian. And they haven't gone down the path of guardianship because usually it's this intermittent time where they are not able to make their own decisions, and then we get them stabilized and hopefully discharged back to the community, and then they're making decisions again until there's some sort of exacerbation. So, and we're not really looking, and I would say for people that have psychiatric disease, sometimes it's tough to find people willing to serve as their guardian because it's not an easy job. And so, you know, we do our best, but certainly a voluntary guardianship is easier to undo than an involuntary guardianship. So thank you all for calling in.
Yes, thank you.
Thank you.
Very, very excellent talk. Again, just to remind you, this is the QR and the link to giving us some feedback about your reactions to the presentation and getting your CME credit. And once again, the recording will be available for your colleagues on the OneCare website. Have a great afternoon. Bye-bye.
Thanks, everyone.
Thank you.